Minister for Home Affairs.
Mr. Speaker, sir, I thank the members who have spoken. First, let me deal with the need for the Act. Mr. Gantiampo has cited several surveys which tell us that we are among near the top, the Safe Cities Index in the world, and we are right at the top in terms of law and order. I have shared with members the findings of another survey. Here, 93% of our residents say they feel safe when they walk in their neighborhood at night. "92% say they rate safety and security in Singapore as good or very good. The reason is not just the CLTPA, it's the entire criminal justice system. Mr. Kok Heng Leun, an MP, cited the Rule of Law Index, pointed out, said we were ranked 13th globally. He left out the fact that in that ranking, we were ranked first for order and security and fifth in the world for criminal justice. He says we can borrow legislation from the United Kingdom to replace the CLTPA. The UK is ranked 21st in the world for order and security and 11th for criminal justice. But let's not get carried away with these rankings. They are not the gold standard, the holy grail, by which we should automatically judge ourselves. They're only indicative, and sometimes, or at least some of the surveys, the methodologies are highly questionable, right? So in the end, we really have to use our common sense, the facts as we can see them, what is in front of our eyes, the lived reality in the United Kingdom, in Singapore, in other countries. As MPs, many of us, in fact, all of us should be, on the ground regularly. We know what our residents want. We know what they feel. Will we be happy to have the same situation as the United Kingdom? According to the BBC, a knife or blade was used in a crime every 16 minutes on average in the United Kingdom in 2016. The number of incidents involving machetes has risen more than 60% in recent years. The Metropolitan Police Commissioner has said the menace of knife crime caused by London street gangs is a significant issue. They are dealing or trying to deal with problems that we have kept at bay. And if you look at America, people compare us sometimes, so you've got to look at city for city. Gallup poll in 2017, Americans with a great deal or quite a lot of confidence in the police stands at 57%, compared with our percentages in excess of 90. 30% of Americans said they were afraid to walk alone at night in an area within a mile of where they live. These are broad trends. They are not attributable to a specific factor or specific legislation. But really, we have to think of what works for us and think carefully before we try to cut and paste systems from other countries. And frankly, not be colonized in our thinking. If something works well outside, sure, we should copy it, and we do. But we don't copy it simply because it is somewhere else, without giving due consideration as to whether it has worked well. And we need the self-confidence to ignore it when others shout loudly that they have the best systems in the world, if the facts don't bear that out. In terms of the timing of extension, Mr. Pillay asked why we are extending the Act now. We are making a number of amendments, and I'm taking the opportunity also of extending the life of the Act at the same time. I think Ms. Lim also asked this question. The last debate was in November 2013. That's about 4 years and 3 months since the last debate. We are putting in a schedule. I've explained why, and I will explain why again. We are putting in more flexibility in terms of our PSOs. I explained you want to tailor the conditions imposed on individuals for rehabilitation, for counseling, and so on. It can't be difficult to have it in the main legislation. So since we are making those amendments, we are seeking an extension by explaining it clearly in Parliament. Otherwise, we would have waited. So I agree, normally it should be nearer the renewal date, not right at the door, but nearer. But since we are doing these other amendments, we are coming with a request for extension as well. I will now deal with 3 main issues that members have brought up. First, the finality of clause. Second, the listing in the schedule. And third, the safeguards in the Act. Several members have spoken about the finality clause in the bill. Mr. Ng asked whether the finality clause was intended to exclude judicial review. Mr. Kok Heng Leun worried that the amendments removed judicial oversight over the legality of the minister's decision. Mr. Ng and Mr. Gan also suggested we need independent court oversight in the system. And I think all of Mrs. Pritam Singh, Ms. Sylvia Lim, and Mr. Dennis Tan also had questions. Let's take a step back. Let me explain this by reference to some broader points, and then I'll deal with the specific points. In the criminal justice system, you have trials, you have verdicts, guilty, not guilty, and for those who are guilty, the penal system provides for punishments. It generally works well in Singapore. It works well because people know that if you commit an offense, you are likely to be picked up. And if you are guilty, you are likely to be found guilty in court. And if you are found guilty, you will face penalties. And all of this will take place fairly quickly. The exceptions to this process, Internal Security Act, the CLTPA, and of course provisions in the MRHA. It's a deliberate decision by Parliament to make those exceptions. Why? Internal Security Act, reasons have been explained. CLTPA, Ministers for Home Affairs have explained it regularly in this House, and I have sought to do so earlier. The real world comprises gangsters, kingpins, UML attacks, threatening of witnesses, what I said to you about the UK. And let me read this out about Sydney. This is from the Sydney Morning Herald. About an incident, it's just one indication, one incident, but it tells you what happens and why we don't have such things in Singapore. The leader of the Comanchero outlaw, this is January 30, 2012, 6 years ago, an article. Leader of an outlaw Bikie gang is refusing to cooperate with police after surviving another attempt on his life, a shooting that also killed his son. Vincenzo Forcarelli is in hospital with gunshot wounds, refusing to tell police who shot him and killed his son Giovanni, 22, at Dry Creek in Adelaide's northwest last night. It was the 4th attempt on Vincenzo's life. He was shot in the leg in December, was also the target of a failed bomb attack by 2 men linked to the Hells Angels, who both died when the device exploded early. He reportedly taunted his rivals on Facebook a day after surviving the 3rd attempt on his life, including boasting that he had 9 lives. He can be seen dancing in a YouTube clip that appears to be promoting life in the Comanchero gang in Adelaide. Detective Superintendent Grant Moyle said police would do everything they could to prevent retaliation. This is after 4 times. I would suggest it was very planned, targeted attempt on his life, he told reporters at an overnight press conference. It is a concern to us that retribution might take place, but we will do what we can to talk sense into these people. You can just imagine trying to talk sense into them. He has declined, he meaning Vincenzo, has provided us any information that might assist us in identifying the offender. That is a difficulty we face in these particular cases. The people that do know information are often reluctant to assist the investigation. So here you have a man who is publicly known as being part of a gang, whose life has been attempted on 4 times. His son has been killed. He is in hospital. He is refusing to talk. And the police fear that there will be retaliation. The police say we will try and prevent it. But we know in the real world what happens. She said South Australian Police Minister Jennifer Rankin will be briefed on the shooting by Police Commissioner. She said police were doing their best to deal with the scourge of outlaw gangs, and South Australia had very tough anti-bikie laws. Hundreds of them have been arrested and charged. Hundreds of their associates have been arrested and charged. The frustration in these people have absolutely no regard for the law, or it would appear for their safety or the safety of the community. The reporter points out that his son also had been attacked before but had refused to cooperate with police investigating the attempted murder. So police then were going on a door-knocking exercise to try and get evidence. We don't have these things for one simple reason. It's not that we are automatically different, but we have become different. If there are gangs, and there are, we intervene very early and we break them up. We don't allow them to get to this situation. So this is the trade-off I talked about. It's no right and wrong approach, but you have to be very clear about what the trade-offs are. Now, we are not immediately, supposing we remove the CLTPA, going to get to Sydney's situation straight away. We have tough gun control laws as well, but you must expect a different law and order situation. Some of you might recall, I think it's 2010, 7 years now. Over a period of 3 weeks, a series of young boys went on a rampage, different groups. I think one was in downtown East. A young man was knifed, I think, to death. He was knifed to death, gang attack. And then in Bukit Panjang, the following week, there was another attack. 3 weeks in a row, and people got upset, and they said, what is happening? Do something about it. The police took a number of steps, did something about it, but the CLTPA is an essential tool in the arsenal of doing something about these things. Otherwise, every MP, Member of Parliament, will answer to your residents, because our people value law and order and security very highly. And 93% of the people are not going to say in a survey they feel safe walking in their neighborhoods. Our people get upset with UML cases. When paint gets splashed, MPs would have faced them. When their doors get locked, padlocked. When their doors get set on fire, they will come to the MPs and demand that action be taken. And the government has got to be able to respond. So, right or wrong, as I've been upfront about it, you can choose either path. as long as you're clear about the trade-offs. And society as a whole must be prepared to accept the trade-offs. I have come to accept that the path we are taking is probably better for Singapore and for society. Let me again, make a larger point. It's possible to make grand statements about liberty and security if you don't have to deal with real-world problems. Let me go to the US as an example. President Obama, when he was candidate Obama, he thundered, choice between liberty and security is a false choice, he said. Meaning you can both have security and a full set of rights, including due process for all in the courts in all cases. Sounds very good. It's very noble. And he promised to close Guantanamo. Signed an executive order in 2009 to close Gitmo, in fact. But then the US was having trouble finding anyone else who was willing to take all these people in Gitmo. Prisoners there were indefinitely detained without charge, citizens from 49 nations. Youngest detainee was 14, oldest was 89. The president then tried to move them into centers in the United States. There was a big outcry. Senators did not want Gitmo closed, and they certainly did not want these prisoners in US soil for all the rhetoric from the US. The majority of Americans also opposed bringing the detainees to American soil. So the president recognized the difficulty almost immediately after he took office, and is a constitutional law professor. So he said in a 2009 speech, after he became president, there remains a question of the Gitmo detainees who cannot be prosecuted and yet who pose a clear danger to the American people. And I have to be honest here, this is the toughest single issue that we will face. And he said, even after the process is complete, there will be some who cannot be prosecuted because there will be a lack of evidence, but who nevertheless will pose a threat to the security of the United States. And he said he is not going to release those individuals. So that is where reality meets rhetoric. If you look at Eric Holder, the former Attorney General of the United States, he was giving evidence in Congress about one of the masterminds of 9/11. He was asked what will happen if they tried the man, and he was acquitted by the courts. His answer, we would like the courts to convict him, but if for some reason he's acquitted, we will detain him. It's again the reality of the situation. So members know for years we have been lectured about the Internal Security Act, particularly by the Americans. But when they faced 9/11, suddenly the situation is different. Of course, the CLTPA is not in the same league as the Internal Security Act. It deals with different situations. It's very different from the ISA. The principle behind the CLTPA is that there will be some criminals, some types of criminals. Due process will not get them to justice, considering the nature of their activities. Is it better for society to leave them out or have the CLTPA and use it? Our current approach has led to the current levels of safety and security. Safeguards, I've mentioned several, including the advisory committees, the structure of how we proceed. Now, in this context, let's turn to Clause 3. Mr. Pritam Singh said, or asked if he said, Clause 3 operates to narrow the judiciary's role. Say, how so? How does it narrow the judiciary's role? He asserts but does not explain. And I have said, I think by now I've said it about 4 or 5 times, there is no exclusion of judicial review. The traditional grounds of judicial review remain. So here we are. I have explained by reference to first logic, in that clause 3 deals with the factual basis for the minister's decision. Judicial review is separate. Second, I've explained that a half-decent, and I don't mean it in an insulting way, but basic point is any lawyer ought to know that regardless of what I say, clause 3 cannot oust judicial review. That's a fairly basic, fundamental point. Any lawyer ought to know. So I've explained it, and I've given reasons. So I'm faced with an assertion from Mr. Singh, and this is the best I can deal with it, unless there are some reasons given to me as to why he thinks, or Ms. Lim thinks, or anyone else thinks, that this narrows the judiciary's role. The Court of Appeal itself says, and I've repeatedly made that point, I haven't read out to members the various passages, but they make the points quite carefully. They set out the grounds for judicial review, and we accept it, and nothing here affects those grounds. And Hansard can be referred to in courts, and I'm saying that as a law minister. Second, I say as a matter of law, people will know that it cannot affect. Third, the court also said they will accept the minister's decision on the facts. That's intended to be the structure of the CLTPA, and that's the right approach. And that's all that clause 3 does. Minister's decision is final. That doesn't mean, what does that mean? You cannot go and appeal to somebody else and say, minister made these decisions, his finding of facts are wrong. You can judicially review it on the grounds for judicial review. The courts are not to substitute their views of the facts or engage in an exercise of scrutinizing the evidential basis for detention. That is all in the Court of Appeal judgment. That's not affected. That is and has always been the law. Mr. Singh asked whether the courts can go behind the minister's decision and review the background facts behind the decision for the detention order. The courts are not to substitute their views on the facts for the minister's views. That's a current position. Read the judgment of Denton, or read Denton's Court of Appeals judgment in Denton. As Mr. D'Souza and Ms. Rahayu pointed out, the amendments are in line with the Court of Appeals decision. Mr. Pillay had some questions on the judicial review point. I've explained the approach, the philosophy behind the CLTPA, and the fact that facts are for the minister to decide upon. On safeguards, Mr. Ng asked for assurance that the amendments will not dilute the requirement that the minister has to provide full grounds for detention. It will not. Mr. Ang, Mr. Gan, and Mr. Mohan have asked about abuse of powers. I have talked about the inbuilt procedural requirements, the parties involved, the processes, and in the end, when you give such a power to the executive, that is the concern that there is some scope for abuse. You try and cut it down. Philosophically, you can say, I don't want to give those powers, and I'm prepared to take the trade-offs. That's for members to decide. But I think you should decide by accepting that if you don't have the CLTPA, then your law and order situation will get worse. How much worse? It's not possible to say, but it will get worse. And whether you're prepared to justify that and take that kind of society. Then we come to the fourth schedule. Mr. Ng asked whether the list, having a list, will reduce the pressure on the executive to explain and justify each decision. I do not see how this will be so, and again, a misunderstanding. You see, the current requirements under the Act, it sets out under Section 30 what the grounds for detention are. Those grounds remain. So again, I scratch my head when people complain about the schedule. Those grounds remain. All that is being done is, on top of that, in addition to those grounds, you also got to go and show, the minister has got to show that the offense or the nature of the activities are also listed in the schedule. So you got, previously there was one requirement. You show that the facts or requirements of Section 30 are satisfied. Now there are two requirements. You've got to show that the requirements of Section 30 are satisfied, and in addition, that it's been listed in the schedule. So it's not the case that if he is listed in the schedule, he can automatically be detained. There has got to be, it's got to be shown that it was necessary to detain him in the interest of public safety, peace, and good order. Ms. Lim, at some points, I tried listening very carefully. I have to say I found the points a little difficult to follow. What I got out of the points under here was that it increases the powers of the minister. I think these statements, they're difficult to deal with because they've got to be backed by some reasoning and some logic. So I come back to this simple point. You have Section 30. It says what the grounds are. That's the situation today. The Court of Appeal pointed out it's not unlimited power for the minister, but there is, it's not open-ended, but it gives a level of discretion. After the amendments, assuming they are made into law, what's the situation? You continue to need to satisfy the requirements in Section 30. So the detainee is no worse off, the minister is no better off. The same requirements continue. In addition, the minister has got to show that it's listed in the schedule. So how does it increase the powers? I think rhetoric has got to match reality, and it's useful to read the clauses carefully before making speeches. Previously, when there was no list, some members rose up, or at least one rose up, to say, why don't we have a list? Now that we have a list, people say, why are we having a list? Mr. Ang Wei Neng asked how the list was drawn up. Mr. Mohan asked for the rationale behind the organized crime offenses. The activities in the list include criminal activities that have previously been dealt with under the Act, or as I said, or which have been mentioned in Parliament as being within the scope of the Act. Now, supposing, let's do a bit of thinking, the minister lists shoplifting as an offense. And then based on that, he goes and detains a 12-year-old on the basis that this is contrary to the safety and preservation of public order in Singapore. Do you think that will pass muster on any judicial review? So one has got to be sensible about these things. It won't pass muster now before the legislation is amended, and it won't pass muster after tomorrow. We included organized crime, but it doesn't mean everything in the organized crime comes within the CLTPA. It can't do so. But we wanted to preemptively, decisively prevent organized criminal groups from establishing a foothold in Singapore. Mr. D'Souza is correct to say that this recognizes the problems associated with transnational criminal syndicates. Let me deal with some of the other clarifications that have been raised. Mr. Singh asked whether the Act will be used against foreigners who dabble in organized criminal activity that has effect in Singapore. The CLTPA can be used to detain a person if he is associated with criminal activities stated in the fourth schedule, and if detention is necessary in the interests of public safety, peace, good order in Singapore. That doesn't depend on the person's nationality. So action can be taken against foreigners if the conditions are met. I think Ms. Lim, again, another flourish, a rhetorical flourish. I will become a global policeman with a bill. It makes a good soundbite, but it's useful for MPs to read the bill before they make speeches, because we are dealing with serious matters involving the safety and security of Singaporeans. I will repeat again. Not only must the criminal activities fall within the list, a detention order cannot be issued just because an offense under the OCA is disclosed. It must be brought back into Singapore in the sense that minister must find it necessary that the person is detained in the interest of public safety, peace, and good order within Singapore. Within Singapore. So I don't know where this global policeman comes, except perhaps it makes for good reading on a website where one can put out these things, sound bites, without reference to the legislation, the bill, or the clarifications. If and only if the criminal activities, wherever conducted, impact within Singapore in the way set out in Section 30, we should ask. What Mr. Singh asked, what's the threshold of evidence for OCA crimes to fall under the CLTPA? The OCA does not provide for detention without trial. It requires witnesses to give evidence in court. Where witnesses are not willing to do so for fear of reprisals, the CLTPA can be used as a last resort tool, provided Section 30 is satisfied. That is the position today. Mr. Mohan, Mr. Ng, Mr. Christopher D'Souza asked about the PSO obligations and why we are moving the list of obligations to subsidiary legislation. The obligations I explained. You want to look at each supervisee, and you want to tailor the conditions according to the supervisee. Some people may need counseling, just as an example. Some people may need rehabilitation. These are not detainees. There's some conditions imposed on them to come back for urine tests and to be under general supervision. If it's in the main legislation, we will need to amend the Act each time we want to add conditions in based on evolving needs. These are largely operational in nature and make sense to put them in the schedule. Mr. Ng asked about the extension of police powers to CNB officers. Currently, both police and CNB supervise the supervisees. But as I explained earlier, only the police have the power to investigate breaches of PSO obligations. The amendments will streamline the process So we won't need both police and CNB to be deployed to investigate breach of PSOs involving persons detained by CNB for drug trafficking. Mr. Ang also asked if the government will publish the names of the advisory committee members. I think the members can choose to identify themselves if they wish, and some have done so. But the government respects some of the members' wishes not to have their identities published. Sometimes they are also concerned about the people they have to deal with and what might happen to their families. Mr. Gan and Mr. Kok asked about the President's role. Matters relating to the CLTPA do not fall within the President's discretionary powers. The President acts on the advice of Cabinet. Mr. Ng and Mr. Kok also asked whether other legislation could be amended to address the difficulty in securing witness testimony in open court. The general approach I've said, where we can, we want to move towards trials. So these and other suggestions have been considered and not workable we found because of the nature of trial process is such that it's difficult to have a secret testimony from one witness who cannot be cross-examined and whom the judge can talk to but no one else can talk to. It's not the normal trial process. And we pretty much have something similar now through the advisory committees. But we will review them. Mr. Ang Wai Ning also spoke about persons under 21 who were detained and said each child was precious. I wish to assure member, we only act when the risk of reprisals is there. Then we act against these persons. And the persons detained are not quite innocent children. They use deadly weapons. They recruit other members. They attack people. And in a way, you need to remove them from society so that other people of similar age are not influenced by them. That's the way you keep the problem under control. But where possible, charge them in court. If not possible, then use a CL if it is necessary to do so. Mr. Gan wanted to know if there have been cases where those involved in criminal activities had continued to be members of secret societies and whether they committed offenses repeatedly. I think of those currently under detention, about 17% have been placed under detention previously. Mr. Ng asked about the number of cases over the past 5 years in which the advisory committees made a recommendation to detain, but this was not accepted. I can say this. Advisory committees have done so, do recommend against DOs, and in the vast, significant majority of these cases, the government then accepts their advice and instead imposes PSOs. But there have been a small number of cases where the government disagrees. Professor Mohan asked the Constitution, the tasks of the IAC, Independent Advisory Committee, do they change by reason of these amendments? No, they do not. And they do not change by reason of the appointment of judges. In the past, our approach has been to appoint a very senior lawyer or retired judges, but I felt it would be good to appoint serving judges, but it doesn't change the nature of the advisory committee.
Leader.
Speaker, may I seek a consent and the general assent of members present to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48-8 to remove the time limit in respect of Minister Shanmugam's speech.
I give my consent. Does the Leader of the House have the general assent of honourable members present to so move? Leader, please proceed.
Mr. Speaker, I beg to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48-8 in respect of Minister Shanmugam's speech.
The question is as moved by the Leader of the House. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Mr. Shanmugam.
As regards the points made by Mr. Singh, so the question is, since I've explained what finality means, you cannot appeal against the minister's decision on the facts, which is the current position. Really then, Mr. Singh, as well as the other members from the Workers' Party, and all members must ask themselves some questions. First, what is the current position? Do you agree that in the current position, there cannot be an appeal against the minister's decision on the facts? These are fairly basic questions of law. Do you agree or do you disagree? The Court of Appeal has said you cannot appeal against the minister's decision. Minister's decision is not to be substituted. So it's fairly clear. If that is so, then why do you disagree with a clause which sets that out? So again, there's got to be some connection between rhetoric and reality. Mr. Singh also asked whether having judges sit on advisory committees conflates the roles of the judges and that of the executive. No, not at all. The judges sit as part of the advisory committee. They give their views. They look at the evidence. If they feel that some things need to be checked further, they can do so. They can call up the investigation officers. They can call up for the files. They review it. I think we should welcome what the government is doing. But if Mr. Singh or anybody else feels that we shouldn't do so, I would like to hear that. Please stand up clearly and say, no, we don't want judges in there. Say so and put it on record if you mean what you say. Separately, if the detainee feels that the grounds are not adequate and he wants to go for judicial review, it's open for him to go for judicial review. And of course, different judges will hear that application, not the judges who sat on the advisory committee. So having judges who are independent, I think adds considerably to the robustness of the process. Mr. Dennis Tan, I think, referred to my speeches in '89, but I think he conflated the '89 and '94 speeches. I made two speeches. I haven't looked them up recently, but from my recollection, what we are proposing today to have judges chair the advisory committees is similar to what I had suggested in, I believe, '94, some 23 years ago, or 23 and some years ago. I don't think I made that suggestion in '89. I stand corrected. At the same time, I think I suggested some additional appointees to the advisory committee that we are not proceeding with. Mr. Denistan also said this is a step back. I would welcome him to clarify why he says that. How is any of this a step back? Again, it's an assertion which is not being substantiated. I'm standing here and saying that this doesn't oust judicial review. I'm saying any lawyer would know that. I'm referring to the judgments of the Court of Appeal. I'm saying that the finality clause refers to ministers' decisions on the facts, which the Court of Appeal acknowledged. And I'm saying it's crystallizing the current position. So why is this a step back? It sets out clearly it's better as we go forward. Mr. Denistan also made this suggestion, and this is quite a radical suggestion. Remove the role of the president, give it to the courts to review. Essentially, I think you need to be very clear about what is being suggested. It's the suggestion that then we do away with the CLTP altogether because courts, I told you, is a trial process. Is that what you want? That's a fundamental difference from the CLTPA process, which is why it took some time to explain how the CLTPA and the ISA are processes which stand outside the usual trial process. So if you say substitute and bring the courts back in, effectively you are saying remove the CLTPA, just have the trial process. You are entitled to say it, but that looks to me the suggestion, and which so philosophically it's very different. Ms. Lim made similar points on finality and timing. Timing I've dealt with, finality I've dealt with, and I've said on the schedule I don't see how it increases the minister's powers. Mr. Ang also asked about the process of hearing by the advisory committee. In accordance with the CLTPA provisions, all orders made by the Minister for Home Affairs must be referred to the advisory committee within 28 days from its issuance. The persons issued with the orders will be informed of the grounds of detention. They will then appear before the advisory committee and could be legally represented. The advisory committee will consider and submit to the President a written report on the making of the orders and the recommendations. President will consider the report once received and can cancel, confirm, or vary the order, but acting on the advice of Cabinet. That is a very technical, clear meaning. Family members of the accused are informed by my ministry once the outcome of the hearing, on the outcome of the hearing, once this process is carried out. I should add this in answer to Mr. Singh's question as to whether there's a conflation of the role of the executive and the judicial in introducing sitting judges to the advisory committee. I think Ms. Lim said this in 2013. She made, if I'm wrong, I'll be corrected, what was in essence a similar proposal that we have a sitting judge review the merits of a DO in camera. She said, if I heard him correctly, he was actually suggesting that a current sitting judge who is from the judicial branch actually be involved in the advisory committee, which is also, in a way, what I suggested earlier, except that it was in relation to the judge sitting alone. So I would like the minister's comment on that, whether the government is considering getting a sitting judge currently in the High Court to be involved in this process, looking at the merits of the detention order. I said something like this in 1994 or 89. Ms. Lim said something like this in 2013. Mr. Ang asked about the provisions of legal counsel to detainees. While the CLTPA is not covered by CLAS, Criminal Legal Aid Scheme, detainees who cannot afford a lawyer can be referred to the Law Society, and they will seek to assist. They have the pro bono services and the ad hoc pro bono referral scheme. So the LPBS will assess the case and arrange for pro bono legal representation as appropriate. So I think I've dealt with all the points the members have brought up. And given that some of the members appear to have proceeded on a completely erroneous set of assumptions of law and perhaps a misreading of the bill, I wonder if they will now change their position when it comes to voting, because otherwise they'll be voting on a mistaken basis as well. Thank you.
I'd like to open for points of clarifications. Monsieur Willem.
Thank you, Mr. Speaker. 3 clarifications I wish to make. In relation to Clause 3, which introduces explicitly a finality clause into the bill, the minister keeps insisting over and over again that there's no change in the law, there's no intention to, he said, oust judicial review and so on and so forth. But if the government's intention is really to preserve matters as they are, and by that I mean the extent of judicial review will remain the same as what it was in Dan Tan's case, why bother to legislate at all? Why not just leave things as they are so that everyone is clear that there is no curtailment or even a slight limitation or change in the scope of judicial review? That would be the simplest solution I think the government should adopt. Second clarification, and this is in relation to the schedule. Now, again, the minister was saying that everything still relates back to Section 30. In other words, we have a schedule there, but no matter which activity is being picked, the minister would still have to be satisfied that Section 30 is complied with. In other words, the activity is affects the peace, good order, and so on in Singapore. But the fact is that the 4th schedule, by importing the Organised Crime Act, now explicitly has an external focus, meaning that if you look at the OCA, Section 48, it defines organised criminal activity to include activities that are primarily conducted overseas. So this is where my global policeman phrase comes in. Now, in other words, the minister can now look at activities done overseas, and he will simply have to make a statement to say he's concerned that they will take root in Singapore, and that would justify a detention under CL now. And once again, the same question will come up. If the concern of the CLTPA remains the same, in other words, the primary rationale is to protect peace, safety, and good order within Singapore, there's no need to make all these changes. The law already provides for the minister to safeguard peace, safety, and good order within Singapore under the current provisions. And despite my own reservations about the timing of the renewal being premature, the Workers' Party would have been prepared to support a renewal of the Act if not for these 2 changes in Clause 3 and Clause 8. So it would be good if the minister would clarify whether he's prepared to actually just go back to the status quo, ask for a renewal of the Act for 5 years, and then we can all support it because we all want Singapore to be a safe place.
I don't know. So you would like
Minister.
me to respond? Yeah. Okay. I think the first point is that I keep insisting that there is no intent to oust. I make 2 points. First, as a matter of law, this clause cannot oust judicial review. And I buttressed it by saying that go ask any lawyer. Second, and because I've been advised so, and I know so, and I want to be very open about it, I am prepared to stand up here and say so, as the Law Minister and Home Affairs Minister, that there is no intention to oust, and this clause does not oust judicial review. There are tons of cases that will say that. Now, it's not binary. Therefore, why amend? Why not just stay on to the current situation? But I am making an amendment on something else, on the minister's decision being final. That relates to non-appealability from and not getting the courts or anyone else to substitute their views for the minister's views. Is that the current position? Yes, it is. There is a difference between judicial review and a normal trial process or an appeal from the minister. The two are very different. So to say, oh, I'm worried that this is going to oust judicial review, so why are you making that amendment? I'm worried that that amendment will oust judicial review. There's got to be a connection between the two. What is the connection? I'm dealing with the minister's decision on the facts. Supposing, let me give you an example. Go back to my example. I sign an order detaining a 12-year-old who stole a can of beer, and say, I am satisfied that this is necessary for the safety and preservation of good order and public order and safety and security. You think I can face any court in Singapore and justify that? And you think I can rely on a finality clause? The finality clause deals with something else. It deals with decision on the facts. See a 12-year-old, did he do these things? Judicial review is on illegality, irrationality, procedural irregularity. It doesn't save me from those. So to say I'm worried that these consequences might develop, and therefore please don't amend, doesn't seem to me to be a very logical argument. Second, the schedule. I think I spent a fair bit of time explaining. At present, there is one requirement. You require what is set out in Section 30. You've got to satisfy the conditions. Now, there are two requirements. You've got to satisfy the conditions of Section 30, and it's conjunctive. You've got to show that it's also listed in the fourth schedule. Think whether you are a lawyer or not a lawyer, I think members can understand that doesn't dilute the current position, that doesn't reduce. And I've explained why I'm doing it. I feel it's good to set it out clearly. So to come back and say, why do you want to amend? Why not leave the current situation? We think that this will improve the position, amongst others, of the detainees. Everyone is clear, these are the offenses, but you still got to satisfy Section 30. So come back to this example of OCA. Yes, OCA has many provisions. Some of them are external focus. But the minister has to be satisfied. If he wants to charge somebody under, wants to proceed to investigate, and police want to proceed to investigate, and then AGC wants to charge, they've got to satisfy the elements set out in the OCA. Supposing we want to use the CLTPA, then you don't have to go and look at the elements of the OCA as such, but you've got to show that Section 30 is satisfied, that in some way it impacts on the good order, safety, public security in Singapore. That's clear. It's common sense, actually. Thank you, sir.
Mr. Pritam Singh.
Thank you, Mr. Speaker. Minister, on the finality clause, does it not crystallize the position in law today in Dan Tan such that the courts will be close to consider new heads of judicial review in the future, particularly if even the high watermark of not displacing the executive's decision with their own requires some nuance? Doesn't the finality clause close that off to the courts? Thank you.
It crystallizes the position, again, assuming you accept my point that judicial review, as set out in Dan Tan's case, is not impacted by the finality clause. I think my logic, I've tried to explain a number of times. Finality clause deals with something else, which is the grounds on which the minister makes the order, the facts and the evidentiary basis which the Court of Appeal has said it won't scrutinize. Okay. What it does is the legislation makes clear that the minister's decision on the facts should not be appealed from. That is what it does. So it makes it clear that you cannot go, for example, to the courts and say, I disagree with the minister's decision on the facts for these reasons, and I'm effectively appealing, and I'm asking you to substitute your views for that of the minister. As to whether our courts could go down the route eventually of saying, we will substitute our views for any views the executive may have, and we will disregard all existing law, as to whether they could go down that route, I would be very surprised if they go down that route. And if they did, I think the government of the day will have a duty to come back to Parliament and talk to members of Parliament and say, is this the way we want the structure between the courts, Parliament, and the executive? I think those are discussions for another day. But so far, as you will read the judgments, due respect is given by the courts for the executive and Parliament gives due respect for the courts.
Mr. Pritam Singh.
Minister, thank you for that. I do understand what you are saying, but the point, I think, is in the case of judicial review, because it, like the common law, continually develops, is this the appropriate time for us to legislatively say, okay, this is where we are closing off certain matters insofar as the facts of a grounds of detention are concerned? If the judiciary moves judicial review along, shouldn't then we come to Parliament with the view, as the minister suggested, to change the law even?
I think the question to ask is, are we comfortable with the current position as a right balance between Parliament and the courts? Minister makes a decision. There is a series of processes, advisory committee. Court of Appeal has the powers of judicial, not just Court of Appeal, of course. Supreme Court has the powers of judicial review over the minister's decision. The framework of that, the appropriate balance, is today set out partly in the legislation, partly by decision of the Court of Appeal and previous decisions. Are we comfortable with that? We are. And that is why we are putting it in law. If we are not comfortable with that, I will be standing here looking you in the eye and saying, we need to change it, as this Parliament did for the Internal Security Act.
Mr. Denistan.
Thank you, Mr. Speaker. Just a clarification to the Minister. Just now the Minister suggested that, firstly, he suggested that I may have conflated his speeches between 94 and 89. I have here downloaded from the Hansard, sitting date 4th August 1989.
As I said, I haven't read them recently,
Yeah,
so
I just want to
said I will
clarify
stand corrected.
because that suggestion seems rather unfair to me.
No. what I said is, I think I made the suggestion in 94,
Yeah.
whereas I heard you saying I said it in 89.
Yes, it's
I don't
89.
recall saying it in 89. I thought I said it in 94, but I'll stand corrected.
Thank you, Minister. And then the minister went on to say that I made a, if I remember correctly, a radical suggestion that the courts, the judges should replace the advisory committee. And I think the minister is mistaken. Actually, what I did, as the House members of the House may recall, is that I quoted from the minister's speech in 1989. And if you could bear with me, can I just read a small chunk of it here? And it's very clear, and then I will re-ask that question to the minister again. So let me quote Mr. Shanmugam in 1989. At present, the CLTPA is such that the minister decides on the detention. The advisory committee advises the president, and the president has limited powers, ultimate powers, sorry. I would suggest that the minister still decides on the detention, but perhaps powers of review be given to the courts. The reason I say that is, if the minister takes a reasonable view on the facts that a certain person poses a danger, then presumably the act can be worded such that the courts can look at the facts, the reasons for the minister's decision, and then come down on the side of the minister. If the courts disagree, if the judges disagree, then again the minister's decision will be overturned. So remove it from the president to the executive and give the power to the courts, unquote. So this is not my suggestion. I do not wish to take the credit. Actually, let me ask the question again. I asked the minister, because he brought up to the House that he has asked judges to to chair the advisory committee. So, and I recall that the minister had suggested this in 1989. So I wanted to ask the minister, why did he stop short of not going towards what he has suggested in 1989 and just go, instead, he has asked the judges to sit as chair of the advisory committee. Thank you.
Yes. I was wondering which MP will refer to me my speeches in 89 and 94. Thank you for that. But before we proceed, can I read this paragraph from the judgment of the Court of Appeal? Paragraph 99. Where the executive is acting within the ambit of the powers that have been vested in it by Parliament, then the court's concern is not with whether it agrees with the way in which the powers have been exercised. To suggest otherwise is to displace the choice that has been made by Parliament as to which branch of the government is to be entrusted with the powers in question. The court's role in judicial review, which engages the manner in which the power is exercised, will then be limited to such things as illegality, irrationality, procedural impropriety. This perspective is premised on a proper understanding of the role of the respective branches of government, especially in this context, the executive and the judiciary in a democracy where the Constitution reigns supreme. There are many other points, but I think that encapsulates what I've been trying to say. I don't see how that is different from everything I've said. They have the power of judicial review on those grounds, but where it is within the province of the executive, they will not intervene. And as you see from other passages, they point out the decision on the facts is for the minister to make. That is why Clause 3 is worded the way it is, and which is why I was somewhat confused with the arguments on judicial review from both some of the PAP members as well. But I think it's good that we spoke about this because it helped me understand what the concerns were and helped me deal with it. Because to me it was very clear. I was coming to deal with one set of issues and suddenly a different set of questions were raised. Now, Mr. Denistan, now I think we were speaking at cross purposes. You see, in 94, if I'm not wrong, I suggested that the advisory committees have judges. But that's different from having a quasi-appeal process to the judiciary, which is in 89. So you were referring to what I had said in 89. I thought you were referring to what I had said in 94. What we are doing now in terms of having judges sit in the advisory committee is similar to what I had suggested in 94. So I misunderstood you because I thought you were referring to my suggestion today. Yeah. Now, I think you asked a broader question. Basic question is, I had said all this in 89 when I was 30 years old. And why are we not going down that path today? One can give a short answer, which is, I'm 30 years older today. But now, I believe in the essence of what I've said then. In the criminal cases, the usual process to be tried in court, and that the ISA and the CLTPA form exceptions to the usual process. And really, it is best if we don't have such exceptions or restrict those exceptions. And that's my view. Okay. But over the years, I've also realized another point, and that is that wasn't very central to my thinking either in 89 or 94, but a bit of time spent in practice and on the ground brought home the reality of trade-offs. If you are not dealing with people on the ground, dealing with day-to-day issues, one can get somewhat theoretical about these things. But the law has got to work in a way where it delivers not just grand pronouncements, but actual results. And the question of trade-offs was not something I factored in very strongly in my thinking in 89 and 94. And I suspect for a lot of people who approach these legislation, the assumption is we see Singapore as it is today. This is how it will be even if we make all these changes. Supposing we remove the CLTPA, nothing will happen. I'm not saying that's your position, Mr. Tan, but I'm saying that often some of the people who approach this legislation approach it that way. I don't think you do. I don't think your fellow members do, because you have in the past supported the CLTPA. But I'm explaining my position. The question of trade-offs, the assumption is that nothing will change in the real world, and you can change around with the CLTPA. But in the real world, you have gangsters. I read out to you what happened in Sydney. I'm sure that's not isolated. I'm sure that's a lived reality on a pretty much a regular basis for a lot of people around cities, around the world. They threaten witnesses. The kingpins are quite untouchable by the normal process. So question, and I made it plain in my first speech, you can't say one route is right, one route is wrong, but you can say there are these trade-offs. Are we willing to accept the trade-offs? The current situation of law and order that we have is based on the current legal framework and judicial and criminal legal system that we have. And if you remove the CL or you tinker with it very substantially, you will get, I think, some trade-off in terms of increased levels of criminal activity. Whether they have increased, whether they will increase and how much they will increase by, that's something that one will only find out when you remove the legislation. But UML is a good example. You use it effectively, use other legislation. I told you now we are picking up about 2 persons under CL per year, compared to 20 or so before 2011. But the current structure is also a trade-off in that society then accepts that there is some risk in vesting this power in the executive, which is what we try and reduce, restrain by the safeguards. And I have, for some time now, come to accept that the path we have taken is probably better for Singapore. And but at the same time, I did feel that the advisory committees could be strengthened. And they could be strengthened in the way I suggested in 94, not in 89, but 94. And that is why I spoke with the Chief Justice, whether he would be happy to agree to have 2 of his sitting judges sit on the advisory committee, chair the advisory committees, and he agreed. We both felt it will be good for the process. So from March this year, that will happen. Thank you, sir.
Assistant Professor Madhav.
Mr. Speaker, I thank the Minister for his very detailed responses to us. Can I just ask 2 points of clarification, which I think are important for both the Hansard and my understanding? First, is a question I raised earlier in the speech, but I just want to say it out again. Where there is a judicial review proceeding under the CLTPA, will a written statement of the grounds upon which the Minister made the order, whether it's for supervision or for detention, and which is then referred to the advisory committee, will this statement, as well as the advisory committee's report, be shared with the Judicial Review Court? I ask, as this I think will be very useful for their review, and I note that in the Dan Tan case, it was not made available to the Court of Appeal at that point. My second point of clarification is, I think many of us know that the CLTPA is relevant and necessary, Mr. Speaker. But why not make the amendments that are currently envisioned later, when the CLTPA is typically and periodically reviewed nearer its expiry date?
Minister.
Now, on the first point, Mr. Mohan, you're asking whether we will hand over everything that was discussed over to the courts.
To clarify, just asking whether the written statement, this is required under Section 31, which is given to the advisory committee, that written statement, as well as the advisory committee's report, will be given to them.
Well, our sense is this. The advisory committee reports, in a way, to the president, and you can say the executive branch, but the president, of course, stands a little bit apart from the executive branch, because the minister also gets to see it. We felt that the discussions, the thinking of the advisory committee should be full and frank, and they should proceed as they wish. And if people believe that these things can later on be put up in court and challenged, I think that affects the quality of the discussions. And it affects the way in which people might write out a report as well. So it's best that we keep the advisory committee as a process, put in good people, now put in judges to chair them, let them look at it, and the whole process is one where they can call for IOs. And if the IOs believe that this might ultimately end up in court, whatever they say to the advisory committee, I think with the best will in the world, everyone's behavior might change. So you have that process. At the same time, in court, I've said what the tests are. The courts finally have the power to subpoena documents, to ask for documents. They use it judiciously. For example, if they believed that a certain document was necessary, it is within their power to tell the Attorney General's chambers to produce it. And to think that further, if we believe that the courts are doing things in such a way that affects the fundamental structure of the CL, then the government of the day will have to decide, is this acceptable, we can live with it, or do we have to come to Parliament and say we have to change that? But those are different discussions. But whatever is necessary for the judicial review is put before the courts. Yeah. And the courts, as I said, I don't believe they felt constrained, but they can ask counsel and both sides, including the AGC. Now, why not make it later? I mean, I cannot give you a different answer from what I've already said to Mr. Pillay and Ms. Lim. We've been thinking about this for a while. Some of this, for example, the changes to the supervising order is really something that is quite close to my thinking. I have directed prisons to go, and CNB, DRC, to go much further on the rehabilitation line. Even though we take a very tough line on drugs, my thinking is, in terms of the first-timers, the second-timers, is there a way of looking at them not just as criminals, but in a way that they are impacted by this, and to rehabilitate them? How can we get them back into society? So we are putting in a lot of resources into the front end in terms of preventing them from getting into the system, and then rehabilitating them, working with them, spending a lot of money on that in terms of trying to rehabilitate them when they are in prison, and then hand-holding them when they are out. Now, this is a general penal system. So likewise, for the supervisees, if you don't give them close attention, today you make them report on a regular basis. That alone is not going to prevent them from getting back into bad company, going back into gangsterism. You need to do something more. And so my directions to the ministry has been, can we do something more? Can we tailor the changes such that police can impose certain conditions? I can imagine you got to spend some time with your, doing this, or you have to come for counseling. You've got to do these things, basically to try and get you to break the habit. So that was a significant part of the change, even though it hasn't been discussed today. But by moving into the schedule, it allows us to look at every individual. Today, when detainees come in, we actually do a risk analysis. Are you likely to be high risk, medium risk, or low risk? And if you are low risk, can we do all these things to make sure that you don't become a permanent feature of the system? So likewise, we want to do that with the PSOs, supervisees. We want to structure it such that we have the power to impose those sorts of tailored conditions. And in my mind, the sooner the better we move, in line with everything else. So we're making some other amendments. So we put it all together. And because we are coming to Parliament for the amendments, we said, okay, let's ask for another 5 years at the same time.
Any final clarifications? Mr. Dennis Tan.
Thank you, Speaker. Sorry, Mr. To belabor this. I'm just trying to understand. It's a follow-up to your clarification just now on the proposed system for the judges to chair the committee. For the sure. Yeah. Thank you, Minister. Yeah, I know you mentioned of trade-offs, but I don't think you quite explained what was the reason, why did you shift from one position to the other? Because the way I look at it is, it could be the same 1-2 judges sitting there making a decision. Either in their capacity as Supreme Court judges or as chair of the advisory committee, they could be using the same legal reasoning and all that. So, but Minister correctly observed that between 89 and 94, you have changed this position. You explained that they are trade-off, but could you explain why is one preferred to the other? Thank you.
So you're asking me why I changed my mind between 89 and 94, or why I changed my mind between 89 and 94?
Yes, why are you explained that by 94 you have changed your mind and you recommended, as you are going to do now, that the judges chair the advisory committee. So my question again is, what makes you change your mind? What makes you prefer one over the other? Because as I've said, it could be the same 2 judges sitting there using the same experience and training and making the same decision. Is it not, I mean, are we saying that, is the government concerned that the decision stops there, it overrules the minister and it ends there? And that on the other hand, in the advisory committee, there's a further process of presenting it to the president, and the president be acting on the advice of the cabinet.
Yeah, not
So
quite.
I just need to know the reason for preferring one to the other now.
It's this. You see, even in 89, 94, I didn't conflate the two, because conceptually they are two very different. Which is why, in answer to your points earlier, I said what you are suggesting is quite radical. Radical in the sense that, look, it's either an executive process or a judicial process. So we have to apply our mind. Is it something where you want the minister to decide? Or is it something you want the courts to decide? If it goes to the courts, you know what the process is. It's got to be through evidence. It's got to be through witnesses. When the courts sit and review in open, then the other side will have a right to look at all of the testimony. You've got to give it to them. That undercuts the entire basis for the CL, because many of the witnesses don't want the evidence to come out. So one has got to be conceptually clear. Which route do we want? By 94, I came to the conclusion that it's, if you agree to the CL, then you have to agree to a process where the information and the witnesses are protected. That's fundamental. So, which is why then you have this advisory committee. They can receive evidence. They can choose to share some of it with the defense counsel. They may choose not to share some of it with the defense counsel. They have got to look carefully to see what evidence they want, and they've got to be very careful that they do not expose some of the witnesses to potential harm, witnesses and their families. You can't do any of that in a normal court process, which is why I said your suggestion really means we do away with the CL. You can't have your cake and eat it. It's either one or the other. And you've got to decide which one.
Okay, one last one, Mr. Nestan. Mr. Loh, last clarification.
Speaker, so I'm quite confused with all this explanation. It seems to me the minister is saying that the amendment before the House has no effect on the current legislation as it is. If there's no effect, then what amend something that is unnecessary?
Mr. Speaker, sir, I think I've gone into some length.
Yes, you have, Minister.
Thank you.